Hey, good morning. This is Chris with Suarez Home and Finance. You are on Coffee with Chris, so you're here with us this morning and every Monday at 10 o'clock. So here we are. We've got Jarrod Scharber on this morning with us, and he is with Scharber Law Group or Scharber Law?
Scharber Law Group.
Scharber Law Group. Okay. So Jarrod is a and this is where that I thought about it after I posted it. So there's a difference, I think, between an attorney or a lawyer. Or so are you an attorney or a lawyer, or does it matter?
It doesn't matter. It's all the same thing. I've been called much worse. I can tell you that. I'm an attorney. I'm a lawyer. I'm a counselor in a lot of ways. I'm a licensed title agent, which is how you and I got to know each other through the real property side of our practice. But born and raised here in Dade City, been back here practicing for 15 years, and happy to be here.
Good, awesome. Okay, so Jarrod is going to talk to us about probates, wills, and trust. So this is something that, like with a lot of my clients I've talked to recently, I've experienced when someone passes away, excuse my language, but the shitola hits the fan, and who is left what, all that kind of stuff. And I always, like, we're working on, just like what I had posted yesterday or whatever, we're working on that. I want to do a trust for my husband and I. Who wants their family to go through crap and the stress and everything else of who gets what whenever you pass away, but then also, you know, the fighting, it's just ridiculous. And then you can't, and it's, I was going to say enjoy, but that's not the right word. You can't grieve and enjoy your memories, though, you know, because you're fighting with family. So Jarrod's got 3 of the most common questions that he is asked. And so the first one is, probate really that much of a nightmare and something folks want to avoid? So take it away, Jarrod.
Well, as you rightly point out in your introduction, everybody's perception of probate, especially those who haven't had to navigate it before, they've all got a brother-in-law or a cousin or somebody that they know from work who has told them a nightmare horror story about the probate process and how this was tied up for 2 years while me and my Aunt Sally out in Indiana had to sort this out, deal with creditor claims, deal with our cousin who's in prison and he wanted his share, and mama's will wasn't properly notarized. And, you know, so everybody's got a story, but I can tell you that this is where the value of a simple $250 last will and testament comes in, because the last will and testament, even something as simple that says, at the time of my death, leave everything to my spouse. If my spouse is gone, leave everything to my kids in equal shares. It can be that simple, 4 or 5 pages, and you're out of here. That takes all of the guesswork, all of the nightmare out of the probate process. Every horror story you've ever heard about probate is typically generated out of a factual scenario where there was either no will, so there's a question over, you know, who are the beneficiaries, who are the heirs. Lots of questions related to that when you have people that are either on their second or perhaps third marriage, or they have a blended family. Does children include stepchildren, or does it not include stepchildren when you go to divide up the assets? Lots of infinite open questions that are unanswered, and we have to play that guessing game. And of course, everybody's going to say, well, I know exactly what mama wanted before she died. And everybody's going to have an opinion on that.
I know.
Exactly. Exactly right. And I tell you, it doesn't take but just a few $1,000s to bring out the worst in people. Otherwise, really good people, normal people that you work with and that you see every day. A little bit of money on the line, a little bit of dispute about where that money goes, absolutely brings out the worst. And anytime family's involved, you know, it makes it that much more complicated. So from that perspective, taking the time to assemble a last will and testament that says, this is who my heirs are, this is where I want my property to go, these are the people that I want to leave in charge of getting this accomplished for me. Long as that will is prepared in accordance with Florida law, properly notarized, witness, includes a self-proving affidavit, there's really no chance of the big blowout nightmare 2-year struggle of getting mom's estate through probate. Probate, in a lot of cases here, I'm able to get summary administrations turned over and done in less than 30 days. and formal administration, you have to publish in the paper a creditor period of 90 days. So those take a little longer. But again, you've got this clear roadmap that identifies the who, the what, and the where. So neither the judge nor the attorney that's assisting you, nor the personal representative, or what we used to call an executor, nobody has any questions because it's all there in black and white. So yeah, probate is something to be nervous about and to be mindful of in the event that you're not prepared. But you take the time to write a will, which is something that everybody needs. Take the time to write that will, make sure your spouse has a will, and you're leaving your loved ones, whether that's your kids or related family members, the folks that are going to be stuck dealing with it, you're leaving them in a position to go see a lawyer, hand over that original will, a death certificate, and sit back and let the process take care of itself, because it really isn't complicated, lengthy, expensive. It's none of those things if you have your ducks in a row. So that's, if anybody takes a message away from today, it's go get a will. Have a will.
So let me go backwards. So it's only $250 for you to do a will for somebody?
Yeah, I tell you, and this goes all the way back to my mentor when I first started practicing law here in Dade City. I'm from here. We're fourth generation East Pasco. And my mentor, my law partner of 14 years, Charles Waller, this was something that he believed in, that is something that everybody needs. He wrote wills for free in the beginning of his career for two reasons: A, to get folks through the door, and B, because it was something he believed that everybody needs. Even coming into when I started practicing in the early 2000s, we were doing wills for $100. And I've tried to kind of maintain that because I want it to be accessible to everyone. Okay. And, you know, the estate planning packages, especially if you get into the bigger markets down in Tampa, you can spend upwards of $2,000-$3,000 on these things. But to me, I don't care if you've got $5 in the bank or $5 million worth of investments, you need a will, because again, it's only going to take a few $100 for your family to get thrown into a tailspin and everybody get upset with one another. So come in here, spend an hour with me. Let's talk about what your needs are. And for $250, I can alleviate that concern. I can let them bypass all of that fussing and fighting. And again, that's something that was driven into me at an early stage in my career, that it's an important document and it's a document that everyone needs. So keep it inexpensive, keep it accessible to everyone. So we've continued to try to do that here.
Now, do I have to have one for me and then have to have one for my husband also? So do we each have our own?
Good question. You used to be able to write what was called a joint will. Florida allowed that and permitted that for many years. But the legislature, going back to, I want to say the middle 90s, it might have been the early 2000s, it was before I was even practicing. The legislature eliminated joint wills as an option. So yeah, you both got to come in, even though those documents are going to look virtually identical. It's going to say, leave it all to my spouse, and when my spouse is gone, leave it all to the kiddos, or whatever it is that we're going to do. Each of you will have your own independent will when the dust settles.
Okay. All right. So then that's, well, and this is and if you have talked to me for a long time or listened to me or whatever, I'm the type of person to where that I say, okay, this is my dumb thinking, not that I'm dumb, but you know, my layman's terms or whatever. So in my will, it's going to say, okay, if I pass away before my husband, everything is left to my husband, and then his is going to say vice versa. And then if we both pass away, then it's going to trickle down to my kids, etc. Is that what happens?
That's exactly right. We always try to write these wills in such a way that they're going to stand the test of time. They're not going to be rendered irrelevant just because someone that you've mentioned in the will happens to pass before you. We set up contingencies. If X happens, then we do Y. If A happens, then we do B. We try to do as much of that as we can, because I don't want something as simple as a loved one or a relative passing away to render your will worthless. You know what I mean? So we've got tactics and drafting mechanisms that we use that is going to allow that document to hopefully stand the test of time and last for many, many years.
Right.
Unless, of course, you have significant wholesale changes in your life, new spouse, grandbabies come along and you want to make a provision for them, big time changes we would probably need to readdress. But generally speaking, we draft these things to hold up.
Okay. Somebody's got a question. Hey, Linda. And I make this live, but I don't make it to where that people are everybody's on the call because we want to, make sure and answer everything too. So sometimes I'll pop in and ask a couple questions. So Linda, she's a real estate agent, is asking if there is a will. Most people think that is all that is needed. They do not know a probate procedure is needed. So if you have a will, do you still have to do a probate, or?
You do. It's just much more straightforward and simplified because, again,
Okay.
you're neither the court nor if you're the one left behind to execute this estate, there is no guessing game in terms of who's entitled to what, who's a beneficiary, who's not, what does everybody get. It's all laid out right there in the body of the document. So although, yes, you do have to open probate and move the will and whatever assets and creditor claims are hanging out there through the probate process, that process is infinitely easier when you've got essentially the answers to the test, the map that leads you to the finish line. When you're holding that in your hand, it makes it easier on everybody.
Okay, perfect. Okay. So let's go, which that's great. And again, like what I had said yesterday, that's something that is on, and now for $250, that's a steal of a lifetime. So you need to get on it and do a will.
Yeah, it is. And again, that includes coming and spending an hour with me, asking all of the questions that you want to ask. We then do the drafting. And then we set up a second appointment where you come in, we put you in the conference room, you get opportunity to read it, ask a second round of questions before we put it on the fancy paper, finalize the draft, sign, witness, and notarize, and all that stuff. So it is in terms of access to a licensed attorney, our facility, and the knowledge that we have from doing this kind of work. It's a very manageable price point for what you're getting in return.
And all the heartache later.
Sure.
Okay, so my second question is, or the second thing that you guys had brought up that you had said is, that's asked is, what steps should folks take if they want to avoid the probate process, or just make sure that they are ready for the probate process when the time comes?
Right, and some of that we've touched on in terms of preparation, having that will, making sure it's signed, witnessed, notarized, and executed in conformity with Florida law. That's step numbers 1, 2, and 3. I mean, that's the most important part of the process. In terms of avoiding probate, I get that question a lot. And again, a lot of this comes back to, my cousin Tim up in Indiana. He was stuck in probate for 3 years while they sorted through this and that and the other. And, I don't want to do that. I don't want my family to do that. How do we avoid probate altogether? Well, there's 3 ways to avoid probate. 1, never die. Don't ever die, and then you don't have to deal with the probate.
Right.
In the event that you can't pull that one off, you would need to divest yourself of any and all assets prior to your death. Meaning, go down to your bank, allocate each of your accounts to someone. You can name payable on death beneficiaries. You can name, and that cuts across a lot of different investment products, checking accounts, savings accounts, IRAs, 401k, stocks, bonds, accounts with the big brokerage houses, Merrill Lynch's and Raymond James and LPLs and all of those. You can call them and you can say, look, I want to name somebody that takes over this account or inherits this account at the time of my passing. When that happens, all that person has to do at the time of your passing is present a death certificate. They look at the person who's deceased. They say, I see right here on the account where they've named you, Chris, as the beneficiary of this account. It's now yours. No probate, no court proceeding, no nothing.
Okay, which that's key, because before my grandmother passed away, because I was dealing with her finances, my sister and I was, and so we put all of our names on her account so that she was like, as soon as I pass away, you take all of it.
Right.
So if it's payable on death, nobody has any rights to it except for us.
Correct.
Okay, so you don't have to worry about that. Okay,
right. Even in the absence of a last will and testament or anything, typically these institutions, and all these institutions have their own internal policies and procedures on how to name that payable on death beneficiary. But
Right.
it's usually something as simple as a phone call or a simple form that you fill out. And once that's done, that asset is no longer subject to probate proceedings. It's not going to be subject to creditor claims. It's going to pass directly to the named beneficiary. And we can do the same thing with real estate, believe it or not. You can, and I've been doing a lot of this lately. We put together deeds that essentially say, okay, I want to give my house to my kids, but I don't want to give it away right now for a couple of reasons. A, I may need to sell it for some unforeseen circumstance.
Okay.
I may need to borrow against it. I may need to go see Chris about a refi, pull some money out. And in that case, it still needs to be titled in my name.
Right.
Or I may in the future need to do something with the home. State of Florida allows us to put a product together where I can effectively deed the home from myself to myself and call my ownership interest an enhanced life estate, meaning essentially I own the property for the remainder of my lifetime. I can manage the property, borrow against it, sell it, lease it, make improvements to it. And for all purposes, title is still in my name. But at the time of my passing, what we call the remainder interest. And the remainder interest just means exactly that. What's left? What remains? Did Jarrod sell his house prior to his death? Because if he did, then there is no remainder interest.
Right.
Did he borrow against it? Did he sell a 1/2 interest in it? Did he rent it to some tenants? Whatever the case may, that then would pass to the folks that you name in the deed. So if I wanted to preserve a life estate in myself and leave the remainder interest to my children, same thing. All they have to do is go down to property appraiser's office following my passing, present the death certificate. They're going to look at it. They're going to look at the title of the property and they're going to say, okay, he's passed. You two now own it, meaning my 2 children or whoever I name in the body of that deed. So that's kind of the second way we could bypass probate, is by taking our monetary assets, our real estate, things of that nature, and putting the pieces in place to make sure that they all pass outside of and around the probate process to the folks that we've identified.
Okay, which that one I've not heard of before. So my experience, my whatever story is that if we're labeled or named or whatever in a trust, and I may be saying it wrong, there was a trust and said that this property goes to this whatever, so it's done automatically, and so the attorney did it automatically. But you're not even talking about that. You're talking about that it's just prepared, because I have a client actually that their family named them in the deed.
Right.
But I want to say that the deed is underneath their children's names, even though that they own it. So what is the deed called something special? Like there's a warranty deed, special deed, whatever.
What we call it, and it doesn't actually show up on the face of the document. It's done by way of a quitclaim deed, but the term, and this is a dated term, but it's called a ladybird deed, is actually
okay. That I've heard of, and I've never understood it.
And that's precisely what it is, and that's where you're essentially naming remainder interest holders on your property. But instead of deeding it to them outright, in which case you would lose the ability to borrow money against it, sell it, rent it, you would no longer be the title owner. This preserves the ability to manage and maintain the real estate in any manner that you deem appropriate, while at the same time saying, when I do pass, whatever is left of this real estate goes to these people. So it's an extraordinarily useful tool for folks that, again, a lot of times folks that come in with smaller estates. I got a checking, I got a savings, I got an investment account, I got a couple of cars, me and the wife, and then I got this home that we bought when we moved down from Ohio when we retired, 20 years ago. Because we do have a lot of residents who come down here at retirement age. Their family's not here. They rely on us to help get everything set up and make things as easy for those family members as possible, because at the time of their passing, these folks are going to fly in from Ohio. They're going to stay for a week to take care of the funeral, the cars, the house. They're going to try to take care of all of it. And the more advanced preparation we can do, the easier it is on those folks, when the time does come. And so that ladybird deed has become an extraordinarily popular tool that we've used, that still allows mom and dad to manage the property the way that they want. But at the time of their passing, whatever's left goes to brother and sister, and for them to do as they please.
Right. Okay. Which I loved. Yeah, that's awesome, because again, I've heard of it. I've never understood it. People are concerned about that. And because, to me, is that if that's something that can be done at closing, then do it at closing,
Right.
do it where that it's done and it's over with, and that you're settled, or whatever the case is, so that, and then, if there's no additional fees, then there's no additional fees. But, so, okay.
Well, and that's one thing that we do enjoy, not to get off probate and on to real estate, but that's one thing we enjoy about working with your office and my team here is it's easy to do a purchase and sale and close the deal and deed it over. But we've got some pretty detailed intake forms that we put together where we have people answer a series of questions about what's your goals for this property in terms of how you want it titled. Because the more that me and my team can understand about what your goals are, the better advice I can give you. You may consider taking title as joint tenants with rights of survivorship. You may want to keep it as tenants in common. You may want to do a ladybird style deed and name a remainder interest person on there. Typical transactional office is just going to do buyer to seller and that's it.
Right.
But we really do kind of pride ourselves on trying to learn precisely what these folks are trying to accomplish and deliver as much as we can in terms of not only the title service, but the attorney services as well. That's one thing that kind of uniquely positions us, is that,
which I love that
we can go a little further than your standard title company in trying to make sure that we've got an understanding of what your legal needs are.
Right. And it's not $5,000 because you're an attorney to do the closing either, which
Right. And that's very often
we experience that.
we run into that all the time, that, I don't really want to pay attorney prices, but I tell you, this is another very intentional act by myself and my team, similar to keeping the estate planning documents at an affordable rate. I've set HUDs and closing statements side by side with us and others in the industry. And not only are we competitive, a lot of times we're even less expensive than others that have to make all of their money on transactions. You know what I mean?
Right.
A title company, that's all they do. They have to make a good lick every time they go to the table. Whereas we can close the deal for you. But if I forge that relationship, and while you're here, you say, well, I'm going to come back and see you 2 weeks and we're going to write a couple of wills. And my brother-in-law's kid got mixed up and got himself a DUI the other day. Maybe if I can build that relationship, there's no need for me to charge a heavy fee to close a real estate transaction, because it's one more buyer and one more seller that we get to bring through the office and meet and let them know a little bit about what we do here.
Right. It's to me, it's a win-win. It's a win-win all the way around. So real quick or whatever, Diane. Hey, Diane. So Diane is a past client of mine as well for several years now. So whenever we are closing, whenever somebody is closing, they're doing a warranty deed. So the warranty deed, so do you do a warranty deed and the ladybird, or is the warranty deed the ladybird?
I could probably integrate the ladybird language into the warranty deed itself.
Okay.
And if not, if the interest is coming from the seller to the buyer, again, same exact time, we could do a quick claim deed to record right behind the warranty deed. If it didn't work out that we could get it done at the closing table,
right?
If it works out that we take title as husband and wife, quite literally the very next day, I could do a quick claim deed, which you'd pay minimum doc stamps, minimum recordings. I think you're talking $18, $24 over at recording for the extra deed. So it wouldn't be a huge expense to fix it post-closing if it had to be done with an additional deed. So we could really go either direction there. If very often what's going on at the time of a closing and deal with buying, selling, a lender, moving, and everything that comes along with it, folks haven't given that a lot of thought just yet. So it's very easy after the dust settles to call me or come back in and see me, and we can get the title set up exactly how you want it.
And that's one of the reasons why I've actually changed one of my questions up front is so whenever we go under contract and I'm kind of, as time goes, I kind of edit things a little bit more to just educate my, my clients.
Those forms are ever evolving. You're right about that.
Yes. Yeah. So I ask always up front is who's going to be on the title, who's going to be vesting. And for just those purposes, I mean, I've been at several closings, and they say, well, why is my fiance not on here? Why is my, this one or that one? Why is my spouse?
Because you didn't tell me.
Right. Because they didn't tell us and they weren't on the contract. So we need to do an addendum and so on and so forth, whatever to the contract and all of that, because if it's a purchase, you need that contract in order to add them to the title and the deed.
That's right.
If it's a refi, then we can do it. And that's where you're having the conversation and so on and so forth. So that is the time to do it. But again, it has to be decided up front so that way you're not at closing and then delaying closing, because I know that the Florida statutes have changed last year, I think it was, or whatever, to where that if you were single when you bought a house and now you're married, you can add your spouse and not pay the doc stamps on it.
Right.
So that's been huge.
Oh, yeah.
Yeah, but there's other things or whatever. So you really want to do it at the time if you're buying at the time of closing. Okay, so we are going on. So our last question is, your last that you get asked a lot is, what are the differences between a will and a trust, and how do people know which one they need? And that's my question too.
Yeah, I was going to say, you made reference to this earlier, and I would say of the three, this is probably the most common. I have folks that come to this office all the time and tell me, I'm here today to see about a trust. And then I ask them, well, what do you think a trust is? They don't know. They just know that the guy that the guy that cuts their hair at the barbershop said that he needs one. So he's here to get one. And that's fine. And it's great. And I love it when people come in here and are prepared to ask the right kinds of questions. But essentially, a trust is an entity, just like the way I explain it to folks sitting in my office. I've got two chairs in front of my desk. Very often I'll have a husband and I'll have a wife, and I'll say there will be a third chair over here for the trust. The trust is not you, and the trust is not you. The trust is its own thing. It's very similar to a corporation. The best analogy that I can come up with is it's like an incorporated entity. It has its own taxpayer ID number. It will manage and own and hold its own assets. The idea being that you, at the time of your passing, will have transferred ownership of everything you own to this trust, so that at the time of Chris's passing, she doesn't own anything. There is no estate. There is no probate. There is nothing that is required of us in the probate court, because the trust owns everything. So in terms of kind of a seamless transition during your lifetime, you are the trustee of the trust, or to keep that analogy alive, you're the president and CEO of the corporation. You decide how the assets are managed, whether we buy things, whether we sell things. You can write checks on the trust's checking account just as you would your own normal checking account. So in terms of your everyday practice, it really doesn't impact anything in terms of the management of your individual assets. You're just no longer managing them in your individual capacity. You're managing them in your capacity as the trustee of the trust. Okay. Now, going back to that analogy we talked about, a major corporation, the president of Ford Motor Company falls over dead. Ford Motor Company does not stop manufacturing vehicles, distributing vehicles to their dealers, and carrying on business as usual. They just install a new president and CEO to continue on conducting that business. That's effectively what happens when you pass away and you have your trust lined up. In the body of that trust, you name a successor trustee. In the event that I pass, in the event that my spouse passes, this third person, and it can be anybody, it needs to be somebody with a pretty high level of competence, forgive the pun, somebody that you really, really trust, because they now are going to look to Article 8 or Article 9 or whatever portion of the trust says, following the death of the trustees, here's what you do. And that's where we identify which items are going to which people, whether we're going to sell things, whether what we're going to do to manage the assets of the trust, wrap up the business of the trust. and then make distribution to the beneficiaries of the trust. All of that instruction is laid out in very precise language in the body of the trust. So that successor trustee, very often, it needs to be a close, trusted friend. It needs to be a family member that you can trust to do exactly what you've asked them. It can be a CPA. I've had clients, although I'm not a huge fan of serving in this role, I've had clients name me because they say, look, my kids, I love them, but I can't trust one of them to look after my entire estate, make a truthful accounting to their brother or sister, then pay all of the creditor claims, and then make distribution in a fair way. I just don't think either of them are capable of it. I want you to do it, which I kind of say, are you sure?
Yeah.
because it's not a real fun job, but it's a job that needs to be done. The biggest fundamental difference between the job that a trustee's doing when conducting the business of administration of a trust and the job that an executor or personal representative does when carrying out, let's just say, a normal last will and testament, and all of the assets are in probate. Same fundamental requirements: identify who's owed money, make sure those creditor claims are paid, then identify who the beneficiaries are and make distribution to those beneficiaries, and conduct a very thorough and complete accounting of all money in, all money out, all expenses, all assets, all liabilities. The fundamental difference is that in probate, while working under a last will and testament, you've got an attorney, a guy like me. You've got a probate judge. Right now it's Judge Stearns here in Pasco County. Great guy, good judge. And you've got an insurance company, typically an insurance company that's associated with posting a bond for the successful administration of the probate. You've got all three sets of those eyes on your executor, on your personal representative, essentially making sure that they do precisely what they're supposed to do.
Right.
The probate judge requires the executor to go get a bond. Is the estate's worth $500,000? Okay, you got to post a $500,000 bond, which is just an insurance product. We buy ours from Benji Blessing State Farm up in Green Hill. And what that does is it's an insurance policy for the beneficiaries of the estate, that if the executor or personal representative sees, well, mom and dad's account sitting there with $500,000 in it, I've got unfettered access as the executor of the estate, and they decide they want to go to Cabo for the next 3 or 4 years and run off with all the money, the beneficiaries then have recourse. They can make a claim against that probate bond and say, hey, our executor, our personal representative ran off with our share of the money, pay me. And insurance company will then process the claim, make sure the beneficiary gets what they're entitled to, and then insurance company goes after that personal representative for essentially running off and screwing them over in the process. Now,
okay, so that actually happened to me.
Did it really?
Yeah. So who requires or who makes that executor, because there was an attorney involved, and so who makes that executor buy that bond?
The judge has discretion over whether they are going to order the personal representative to post the bond. Now, 90% of the wills that get filed with our probate court, the person who has prepared that will, the decedent, the deceased person, has included language in the body of that will that says, I hereby waive and ask that the court not require my personal representative to post a bond. Why? Because it's one more expense. And look, I know that my daughter Chris is going to do exactly what I asked her to. She doesn't need to post a bond. She's not going to run off with her brother and her sister's share. We all want to believe that. So
yes,
that language, and it's in most of the wills that I write as well, where I ask that the bond be waived. However, Judge Stearns, to his credit, even in instances where the will says, we waive the posting of a bond, if it's a situation where there's a lot of cash or there's a situation where he's not altogether comfortable, he'll require it anyway. And, the judge might be right, the judge might be wrong, but at the end of the day, he's always the judge. So when he requires us to post a bond, we pay the fee, we post the bond, and then the beneficiaries are protected.
Okay, so we'll have to talk about that later. But yeah, that absolutely happened to me. And that's why I wanted you to be on here, because there's a lot of stuff that I've learned. And so I have that, printer attorney thing on the wall, of things that I've learned that I'm not an attorney, but oh my God, I've learned so much crap.
Well, so you're practically an attorney at this stage in the game. My goodness, everything everything that you encounter from one week to the next. I mean, you're in the problem solving business just like we are. I mean, that's part of what we do. A big part of what we do. But
that's interesting. So,
well, and then when you get to a trust, by comparison, that trustee doesn't have a judge looking over his or her shoulder, does not have an insurance company looking over his or her shoulder, and in a lot of instances doesn't even have a guy like me. Unless they go out and hire a lawyer, they may just say, look, here's the trust. Mom and dad named me as the successor trustee. I'm going to prepare an accounting of all their assets. I'm going to pay all of their bills. I'm going to close their credit card accounts. I'm going to pay the funeral home. I'm going to pay off the one car that they still owed money on. When all that's done, I'll sell the house, sell the cars, liquidate the accounts. I'll divide it in 3 separate piles, exactly what the trust tells me to do. And here's a pile for my brother, here's a pile for my sister, and a pile for me. But all of that takes place without the watchful eye of the probate judge, an attorney, or a bonding agency. So there is, and again, forgive the pun, there is a high degree of trust that comes with the creation of trust. And I've seen this go badly too, which is why when I tell this story, very often those folks that come in here because their barber told them, you've got to go get yourself a trust. After I'm done telling this story, they maybe reconsider and say, well, maybe the last will and testament's all I need. It'll better serve my needs and help me sleep a little bit better at night, knowing that there's a couple of extra sets of eyes watching what's going on. I had a case out in St. Joe, out near San Antonio. Older fella had done very well over a course of years. He had 30, 40 acres of land. I think 10 acres of it was a producing citrus grove, back when we used to have producing citrus groves around here. Right. 20 acres of it was a cow pasture with a herd of cattle on it that was also income producing. The calves produce revenue every year. There was a cell phone tower on the back corner of the property that paid I think $3,500 a month in rent to rent a little portion of his land for the use of the tower. Got 3, not just assets, but revenue generating assets that this man held at the time of his passing. Right. He had an account at Merrill Lynch that had $350,000 in it. He was a saver. He was from the greatest generation. You know how those folks did it. They didn't live one dime beyond their means. They saved everything that they could save. And he had 5 children. One of those children, and these were grown people by the time this happened, they were in their 50s. One of them had worked as a clerk and comptroller for a major automotive dealer. I forget who it was, but basically she knew how to keep a set of books. She knew how to manage money in, money out, receivables, payables, and she seemed to be a good fit for the job. So he named her as the successor trustee. When I pass, it's your job to take all of this, including the revenue generating aspects of my estate, divide it into 5 piles and make it work with your brother and your brothers and sisters. Well, turns out that his trust may have been a tad misplaced. About a year after his passing, 2 of the siblings came into my office, introduced themselves, gave me the background. Our father's dead, been dead about a year. Our sister is handling the trust, and we literally don't know anything. We don't know what our father owns. We don't know what he has. We don't know how much money there is. We don't know if he has creditors that are owed money. We don't know anything. And it seems like a year would have been enough time. And we don't want to be out of line. We don't want to say, hey, we need some info.
Right.
What do we do? So we wrote a very polite letter to the trustee and said, hey, I represent your brother and your sister, and they're just looking to gather a little bit of information. Can we get just a preliminary accounting of what did dad have at the time of his passing? When do you expect you'll take care of creditor claims? What are we doing with the cows? What are we doing with the homestead residents? How do you plan on mapping this out? In the meantime, sister has paid off her mortgage, bought herself an RV, bought herself a boat, is vacationing. She's quit her job. And it was about 18 months before we finally had to file suit to remove her as trustee. And by the time we did so, she'd made about $400,000 disappear. And in an estate that was valued at about $2.5 million, she was she was getting to be beyond her 1/5 share at that point. and clearly didn't have any intention of making an accounting or doing the things that a trustee was supposed to do. But again, the whole reason this happened was because the trust was created and she had that unfettered, unrestricted access to these assets. Whereas in a probate proceeding, she wouldn't have been able to touch anything until she was appointed personal representative. Requires the hiring of a lawyer, the filing of the petition for administration. All of the ancillary documents related to administering the probate would have to be filed. So at that point, you'd have to be nuts to try to run off with something that didn't belong to you, because again, you've got those extra set of eyes watching what you're doing. So that's kind of is that an everyday thing with a trust? No, most trusts are administered in accordance with the requests of the person who created it. Most people want to do right by their parents or their friend or their neighbor Earl, who named them as their successor trustee, and they're having to take care of it. Most people want to do the right thing, but it is a risk, albeit a small one in most cases, that when a trustee can just walk into a bank and take custody of all of your worldly possessions and assets, they can disappear with them just as quick. So again, the more complex the nature of the assets, the more widespread your assets are, the more appropriate a trust becomes, because that continuity of being able to have a successor trustee step in and continue business as usual, sell the citrus crop, hire a cowboy, load the calves, get the money in the bank for this year's crop of calves, make sure the negotiations with the cell phone tower are on track, that those checks are coming in every month, having somebody that can stay right on top of it without any interruption. There is some benefit and there is some value in that. But again, probate administration, not the end of the world if you have to go that direction with just plain old last will and testament.
Okay. Well, we've gone over, but that's okay, because great information and everything else. So, I mean, just like whenever I'm talking to my clients all the time and just talking to people and friends and family or whatever in general, you got to do something. You don't want, we've talked to our kids about it or whatever, our boys, and I'm sorry, but I'm putting everything down. I'm not leaving, and, us dying, and, one child wants the house, the other one never wants to come back because of memories, so you've got two different things, and I'm not interested in my children and my boys, fighting and everything else. They need to grieve us and have the memories and move on. If you want something, then tell me. And so, those have been conversations that we've had now. My grandmother had those conversations. What do you want? Tell me what you want. It's like, okay, that's morbid. Well, it's reality. So tell me what you want.
It's part of living. That's right.
Yeah. So it's not like I'm dying tomorrow, but I would still like to know what you want. And so, for instance, I was telling my husband, I have different rings. I like jewelry. I have, different memories of different things. So I'm going to start writing down, this is when your dad got me this. This is what it meant. This is what this meant, and so on and so forth, so that there's a story behind it instead of just a piece of something.
Right.
So, but yeah, so I appreciate you so much being on here with us. And we've answered some questions that we had. So if you've got any other questions, thanks, Diane. She said, thank you, Chris. I still admire your brains and ethics. I do have those, so that's good. But if anybody has any questions, Jarrod's information is on here, and he's been tagged and everything as well. So you can reach out to his office. They are awesome. So not only the wills, probates, trust, but the closings as well. If you're buying real estate and refinancing and everything else like that. I love working with his office and him, and, takes care of clients just like that we do. So thank you again for being on here, and, look forward to the next one.
Yes, ma'am. Thank you for having me. Y'all have a great week.
You too. Thank you. Talk to you later.